Hello and welcome. I'm really thrilled today to be here with my co-author, Professor Woodrow Hartzog at Boston University Law School. Together, we wrote a paper that recently came out in a final version in print called The Great Scrape, The Clash Between Scraping and Privacy. And I'm really excited to get into this paper and talk about it now that it's done. It's been a long journey with this, and really excited now to show it to the world and get reactions to it. So uh, we were inspired to write this. We started thinking about this because scraping has become so prevalent these days. All the big AI models are scraping lots of data. They're very hungry beasts, and they need a lot of information. And the companies went to, well, it's on the internet, it's out there, so let's just grab it. And they've grabbed ridiculous quantities of data from the internet, including a lot of personal data. And so our focus was on the personal data component to this. What happens with AI scraping when they're gathering all this personal data and then using it for training models, and there are other instances of scraping too that don't involve AI, but that this is a practice that's been going on for quite a while, and that has largely escaped a lot of privacy scrutiny. What are your thoughts on all this, Woody, in terms of scraping and what is kind of going on the ground? Like what's happening?
Sure. Well, so I think that what drew us here was a really interesting problem where, on one hand, there was this claim being made that all information that was publicly available was free for the taking. And that's what was, you and I had both written separately about this being problematic in the world of privacy law and had been discussing it. And then we saw it be supercharged in AI. And at the same time, when people would sort of raise their fingers and say, well, maybe we shouldn't do that as much, we immediately got the response, well, people scrape all the time. And that scraping is, in fact, the backbone of how we find things on the internet and how journalists find information and hold tech companies accountable. And so scraping simultaneously was playing this role that we viewed as vital for all sorts of publicly desirable things, while simultaneously was this act that was seemingly in contravention with most of what we knew to be basic pillars for privacy law. And so when we started unpacking this, one of the things that I really enjoyed most about writing this article was how we got to dive into the history of scraping, how there was a sort of weird pay no attention to the scraping aspect of the development of privacy policy, because the act of scraping really hasn't changed that much since the 1990s. The technical way in which people went about it, it's just that it didn't play quite the role in public discussion that it did now. And so thinking about how, okay, so we've ignored it for this long, how do we then grapple with it now? And I only see the problem even getting more tenuous because the United States is now so knee deep or even more higher. We're up to our necks in the U.S. economy being propped up by the AI companies that rely upon this ability to scrape. But if we're being honest about the foundational principles of privacy, it it it's in conflict with all of those. And so this paper, I really enjoyed having the opportunity for us to try to unpack that problem and try to find some sort of reconciliation, because after, I remember you and I sort of hashing it out one day, we sort of came to the conclusion, like, there's just nothing that that really matches foundational privacy law here? And then what do we do with that when we're done?
Yeah. Yeah, and AI, you're right, it's kind of propping up our economy. I hate to say it, but it's a bubble. It's going to burst. It's just a question of when. But it kind of shades of like, the kind of early days of the commercial internet. We're going to see a burst, and then we'll see what happens in the what grows out of the ashes.
Right.
But I think we're going to see a reckoning. But yeah, I think that, when we looked at scraping and we kind of started to say, okay, we have this practice, a lot is being gathered from the internet, the kind of, I think the tech company ethos is, we're going to grab everything that we can possibly get our hands on because, we're hungry. We've got to make money. We've got to grow. We've got to work fast. We've got to and it's there. So we're going to take it.
Yeah.
And so they grabbed it, and they've been doing this for a long time. And there have been a lot of legal cases and tussles over scraping, but most of them, and when we look through the past 20 years of the kind of legal litigation, the wrangling over scraping, it really didn't focus much on personal data so much as it focused on things like trespass and companies getting angry at each other because they were trying to deal with competitors that were trying to grab their data. But it was a lot of the cases dealt with the Computer Fraud and Abuse Act. Is this some kind of a illegal, unauthorized access to a website or trespass, property concepts? But it was very much founded in all these things, but very little to do with, the kind of basic privacy principles that are the components of privacy laws. Things like, secondary use and data security and various other things like, specifying purposes, notice, giving people the right to, say no, to have a choice or to opt in or opt out. All these are the kind of basic components of privacy law, and yet there were barely any cases on that component. Ultimately, what I think looking at 25 to 30 years of litigation on the Computer Fraud and Abuse Act and trespass and all these other things, it's interesting that after all that, it's like the Crusades. A lot of battles, a lot of carnage, and then at the end of the day, really nothing. Nothing shifts, nothing happens. It's kind of, and that's kind of where we are. It's still not resolved. There's all these battles. There's kind of things pointing different ways, and it's kind of scraping keeps going on, and the legal ramifications of it and all these other doctrines are kind of well, it's really dicey. Sometimes courts will say no, sometimes they say yes. And ultimately, it just kind of keeps going in this kind of weird legal cloud. Although I think that the general winds of the law, it's interesting. They blew one way a little bit, then they blew another way, and then there's a little shifting. But generally, it's kind of at a point where scraping's happening. The law isn't resolved enough to really stop it in these other areas. But there really hasn't been much on the privacy side. So we started to look at, okay, what does privacy law have to say about scraping?
Yeah.
And this was interesting because the law, it kind of also kind of speaks in different voices. Some laws say actually, probably not, it's not legal, but other laws say it is legal due to the publicly available information exception, which I really want to get into you because you've done a lot of work on that. And that's why I wanted to co-author this with you because of that. And that's a big thing in a lot of laws. But then there are other laws where there is a publicly available information exception, but it's not, absolute or as broad as a lot of the companies think it is. And so there's kind of I guess maybe three categories. There's, laws that say publicly available information, very big exception, and we're providing zero protection, go at it.
Right.
Then there are laws that are kind of in the middle that say, well, publicly available information is allowable. You can do what you want with it, but we're going to define it more narrowly. And some of what's scrape falls into it, but some of what's scrape doesn't fall into it. But the company's just scraping as if that category didn't exist. And
Right.
then there are laws like the GDPR where there isn't a publicly available information exception, and that information would in fact be covered, and the companies are scraping it. So in light of that, I wanted to get into the publicly available information exception, which I think the general view of most of the scraping companies is, well, it's publicly available, we can scrape it.
Right. And they've explicitly made that argument. I mean, there's really, it's a really interesting problem because there was an ambiguity that began with whether it was permissible to mass scrape personal information, right? And companies successfully exploited that ambiguity through almost sort of like a blitz scaling attempt where they scraped everything as much as possible, built everything, and then now they say, well, we will go out of business if we're not able to do that, right? And we're already sort of leveraged and normalized around it. And meanwhile, there was no law directly on point around scraping. And I think that not only is there and I would like to talk about the public information stuff, but even before we get to that, I think one of the things that there was a presumption in the law was that scraping was the same as a individualized collecting one piece of information, right? That it didn't think about scraping at scale or over time. And the failure to sort of think broadly and over time about this practice, I think, is what sort of allowed a lot of this ambiguity to flourish. And so there's this persistent, I think, wrongful idea that lingers in certain areas of privacy law, that just because information is made temporarily available to other people, that it's free for the taking, that you've waived any sort of privacy right to it. But that's not how we live our life, and that's not. I've done a lot of work on the concept of privacy as obscurity, and you and I talk about this in the paper, about how people often want privacy in things that they share, even theoretically widely available with other people, but for short amount of time or within certain expected contexts. And the other thing going on here is that just because the concept of public is also a term of art in a way that privacy also is, but the law often gives it this like sort of hard binary, like, did you expose it to anyone? Then it's available to everyone for all purposes. And thankfully, there's a lot more nuance these days, either interpreted into these laws or explicit in these laws. And I think that's where you and I really started to hash out how the mass scraping of personal data is a distinct phenomenon that is worthy of specific legal treatment outside of me seeing taking a screenshot of a website one time, right, as an individual person of one website, right, and to analyze those and think about the differences of scale and time, and then once you look at it sort of in the mass way, then you come to think about it really differently, and that's when we really started turning to data protection law and the fair information practices as taking them on their own terms, comparing mass scraping to them on their own terms. And that's where and I'm happy to sort of go through all the each individual fair information practice. And we were like, fairness is about expectations.
Yeah. Well, let's tackle that in a second, because I do want to make just a couple more points just about existing law. And then, so we did two things in the paper. We kind of looked at, okay, how does existing law wrap around scraping? How does it fit into existing law? Because we really haven't had a lot of litigation or adjudications or enforcement. There was a little bit of enforcement, and the EU started to enforce, and then kind of, I think it was the Italian DPA that kind of said, "Hey, wait a second, OpenAI, your scraping violates GDPR," and then they were made to walk that back. And it's still kind of in this, no one wants to say it, that, scraping probably doesn't fit under the GDPR. No one wants to come out and say it. And they all kind of want to say, oh, well, there must be some kind of way it fits, or maybe we'll just put our heads in the sand and try to ignore the question. We'll try to dodge it because we really don't want to come out and say this, especially in today's climate. No one wants to say no to AI. Everyone thinks like if we say no to AI, we'll kill innovation. Right. Society will ground to the halt, and we're going to live like cave people in the age, but there's that fear. But if we go to the law, there definitely are a number of laws where the laws, I think, unfortunately. We'll get into this when we go into the normative aspects, basically exempt publicly available information. They have a pretty big exemption. And so, the scraping is fair game. Right. Then there are laws like the GDPR where I think that, I think the best interpretation is probably scraping doesn't fit. Or in a much more limited way. I mean, it'd be very, very hard to do the kind of scrapes that a lot of companies are doing under the GDPR. It wouldn't work. Yeah. And then there are laws that are kind of in the middle, which are some of the U.S. state privacy laws and some of the other laws where you have a more narrow publicly available information exception, which means that some of the scraping is okay, and then some isn't. So they're kind of in that murky, partially okay, partially not. But we definitely see that there's going to be a considerable amount of scraping that does contravene the law. But no one's really come out to kind of had the guts to really come out and say it. We're going to say it, and maybe we're going to dare the enforcers to actually, go and waive our article and say, hey, stop it. I think politically it's going to be very hard for them to do something that bold, but technically I think it's going to be illegal some of the time. But then so that's kind of the legal status of it. But right. The normative status of it, we spend a lot of time talking about, well, what should the law do? Is the law right to say that scraping is illegal, let's say, when the laws do, or should the law say no, it's totally fine? And we actually come to two conclusions. One is that the law, not the law, but that scraping essentially is a privacy nightmare. That it's impossible to square scraping with privacy principles, and pretty much it violates almost everyone. We can go into some of that. That's what you're starting to do before I jumped in. And then, but we also come to the conclusion that just banning scraping or stopping it, which would essentially would be, what would ordinarily follow from our conclusions about how bad scraping is for privacy. We conclude actually, well, no. In fact, that we think scraping should be allowed, but in a much more limited capacity, with a different justification than what folks normally think of as what would be allowable scraping. So we have a kind of new approach to when scraping should be allowed and when it shouldn't be allowed. But I guess let's start first with why is scraping so bad for privacy? Like, why is scraping this privacy nightmare, privacy apocalypse?
Yeah, this was a really interesting part because we had taken out each fair information practice and sort of analyzed it. And so we started with fairness, which often hinges upon people's expectations, and people often do not, know that their information is being scraped. They wouldn't expect it when they disclose information on like a social media profile or something like that. And so fairness is about what's expected, and scraping can be hidden and harmful, right? That also, there's an aspect of fairness. And then there's individual rights and control, and scraping strips away the original content of context of the information and puts it in a different context. And so you lose really a lot of that ability to control that information because you don't know whether it's happening or not. And that also works with consent, right? The idea that, you should be able to withdraw your data for certain uses of data. Scraping violates that because it happens sort of off-site, out of context. You've got no idea that it's happening. People are often not able to give meaningful or valid consent. And I've written, and you and I have both sort of written about the problems with that in other areas. Transparency is a major fair information practice, and scraping happens almost completely hidden from view. And then even maybe more seriously, getting into purpose specification and the secondary use restrictions. This is a load-bearing column for data protection law, which is that you should have a reason for collecting the data, and you should be prohibited from using that information for something that it goes beyond that reason. And scraping often occurs precisely for the opposite reason, that it gets hoovered up for whatever possible reason, right? And then used for all sorts of purposes beyond anything that was ever even specified, which usually is nothing. And then that led us to really one of the core conclusions, which is that scraping is basically the opposite of data minimization. That and you and I have had discussions about this, as one of the most important principles of privacy, that it encourages excess and long retention and use beyond purpose. And data minimization is almost the opposite of all of that. Yeah. To say nothing of onward transfer, or whether this information is being adequately secured, and a lot of the other fair information practices. So at every turn, we took a left, scraping violates. We took a right, violates. And so we came to this conclusion that it's just a disaster.
Yeah. And let's look at it concretely, and kind of like, if you look at a couple cases of, one, the scraping of everybody's photo for, by Clearview AI for their facial recognition system. I have a choice. I don't have, how can I not have my photo on the internet? I mean, I have a profile on my law school's faculty page. Right. I don't think I can just sort of not have a faculty profile with my bio and photo. That there's a lot of times where people just don't have a choice. Their information's out there. But I think like a great example is LinkedIn. I think most, pretty much all our audience here has a profile on LinkedIn, and we put information on for a purpose. And LinkedIn, there are privacy protections, right? With my account. Now I have certain rights, right? I can delete my account. I can change my photo. I can change my bio. There's actually protection of data security. So if LinkedIn has a breach, I get notified. I have protections. LinkedIn has restrictions on the secondary use of my data. Data minimization protections. It's subject to all these privacy laws. So I have rights. I have their limitations. LinkedIn is really limited on what it can do with this data. And it has all these obligations to me, and just generally with regard to keeping the data secure and how it's used. And the interesting thing about scraping is, so that means that some random, any stranger from anywhere can go in, scrape all the data, and then they actually can do whatever they want with it without any restrictions. It's not seen as a security breach or violation. They don't have to keep it secure. They can use it for any secondary use and give me no rights on it. And so it's weird, actually, that like the actual company that has gathered the data from me actually is much more restricted than some random stranger that gets it on the internet. So the scrapers actually have a lot more power than the actual company that gathered it in the first place, which is kind of absurd to think about. That, okay, how is it meaningful that I have all these protections, that the law is giving me all these protections against LinkedIn, but then any random company can just get it and then all that's gone. So that's sort of what sparked, if we really want privacy law to be meaningful, it's got to, protect more broadly. And the reality is, and this comes from your work, Woody, is that so much of our information is available online, is out there in the public to some extent. And one thing that when we look at a lot of the principles on privacy law and the way it applies, it actually still gives us protection. And if it wouldn't protect that information, hardly anything would be protected. And it's really hard to imagine how we could have meaningful protection of privacy if we don't protect this kind of information. Like if your information that you put on LinkedIn is not protected, that's a pretty scary anti-privacy world that we're living in. And if everything that you've put online it has zero protection, that's troubling because, my voice, my face, information to identify me, information that you can use to make all sorts of inferences, making an AI of me, all these things could be done without my consent from information that's online. And I think that's the problem that privacy law needs to, even if it doesn't, it needs to protect this if we're going to have any semblance of meaningful privacy protection in today's age. It just has to. Otherwise, privacy laws are a joke, and the protections are a joke. So, ultimately, then the conclusion is, scraping is, if it isn't illegal under privacy laws, it certainly should be, and laws should essentially, the conclusion would be it should ban the practice. But we say, no. So how does that happen?
Yeah. So we talked with a lot of people a lot of journalists, a lot of researchers, a lot of people who work on public knowledge issues and things like that about scraping and how vital of a role that the ability to scrape plays in certain activities that we would say would be in the public interest. And so ultimately in the paper, you and I come down by proposing a conceptual switch, a conceptual reframing, and then we have a specific policy proposal that we put forth. And the conceptual reframing is, I think, is best summarized as zooming out a little bit and taking into account the full scale of information scraping and the fact that it's happening everywhere constantly, and that we're all sort of just gushing personal information that's constantly being put online. And we have two propositions. One, we should come to think of scraping as surveillance in the way in which we look at other sort of sustained information gathering attempts regarding personal information about people. And if you rethink of scraping as surveillance, then that unlocks a lot of frameworks that make monitoring people justified, but difficult, but possible, right, through justification. And so there's that. And then we also said we should also come to think of protecting against scraping akin to a stewardship obligation like we do with data security, so that when you share personal information on a website, then that website has obligations to, first of all, if they're collecting personal data, they're going to have data security obligations, so they can't store your password in clear text and things like that. But there also should be obligations to engage in a safeguarding of that personal information from scrapers. And so those are the two sort of reframing things that we talk about. And then we bring the article home with a proposition that lawmakers should consider a specific rule around scraping that starts with a default prohibition, but justifies it when it's in the public interest.
Yes, exactly. And so we have these kind of several points that you made really, really well. That one, I think, just viewing scraping as an exception to what would otherwise be banned under privacy law, which would kind of shift the paradigm. Because generally, I think, especially in the U.S. approach is, hey, if it's not forbidden, it's allowed. And basically the default is it's allowed unless a law restricts it. The EU has the opposite way. The GDPR basically says it's not allowed unless it fits into a lawful basis, and there's 6 justifications. And that's its approach. And that's one thing from the GDPR that hasn't really across the pond to the United States, though a lot of other things from the GDPR now kind of migrated into U.S. law and in some of the state laws. But that one hasn't. But I think that, if we look at the U.S. law, I mean, it is and should be, ordinarily probably restricted. But then this allows for a shift, right? Well, it would be restricted. We're going to allow it in some cases,
right?
And then so it almost shifts it to the kind of European style of, in a lot of other cases, the use of data is allowed, but this case we've kind of determined it probably shouldn't be, but we'll make an exception. And so now we're shifting to, well, where does it fit into that exception? And the exception is public interest. That and the GDPR has a public interest exception. It's one of the lawful bases, one of the 6 reasons that you can use information. Although that's been interpreted very narrowly. So the way that's understood, it's not the way we want to understand it, and we want to look at that much more broadly as being, we want to have a public interest analysis. Is this really in the public interest? It doesn't necessarily have to be, scraping for the government or scraping for a nonprofit. A for-profit company could be doing things in the public interest with it, but there has to be a justification how there is a public interest. Just scraping data for a company's own AI to make a profit is not going to cut it. Under our view, there really has to be a justification of how, what benefit is this giving to the public, and how is it justified in light of that benefit? Right. And also, as you mentioned too, once it's scraped, it doesn't kind of lose all privacy protections. Now, certain privacy protections, are not going to be practical in the scraped data context, but there are other ones that could be, such as providing individual access and rights to the data, providing other rights, and there's some that we kind of have to sort out, like how does a right to delete would work. But there's others that we would say that it shouldn't be a privacy-free zone once it's scraped. There still are obligations to the data, and it could be seen as a data transfer where those who have it now have obligations as if they had gotten it, through a transfer or a contract, rather than if they got it just by taking it. So we say that there shouldn't be a total privacy-free zone, but there are going to be certain liberties that we're going to allow to be taken with some of the rules of privacy if it's in the public interest, and that's where we kind of try to come out, because there are valuable uses for scraping, and it's very difficult to find a way around it. And I guess one way around it is, you also mentioned how websites should have obligations. That's another thing we talked about, that those who, like LinkedIn and other sites that have information, there are things they can do to protect against scraping, and they should provide some protection against scraping. And there are technical measures they can do to limit scraping. There are things they can put in the terms of service that could limit scraping. They have the ability to challenge scraping, which they should. A lot of times companies are not doing all that they should be doing to address scraping. They just kind of let it go. And I think that there should be more obligations to do what they can, even if it's not perfect, because it's a technological rat race. They still should be trying to engage in that race. Don't just throw up your hands and say, "Oh, well, you've got to play the race and play the game." So that's also part of it. But the problem is that we don't want a world where the only companies that can get the data they need for AI are just like the very gigantic companies like Google and Meta and Amazon. And because if we don't allow scraping, there's no way that smaller players are going to be able to develop AI, because it's just not going to have access to that quantity of data. And that's not a good outcome. It's also not good if we have companies that just say, okay, we'll just sell you the data. You just pay us for it, and then we'll allow it. That still ignores the interests of the individual. So if LinkedIn said, hey, we're going to sell you, a lot of these sites now are like, oh, we're going to sell the data. to scrapers, and they can just pay us for it. I think Reddit did this, and some of the news sites are doing this. But I think that it's not just the property of the company that has it. What about individuals and their rights and their interests, and those aren't being represented in this whole thing. So we need to figure out how to protect those interests as well. We don't want a world where, okay, now these companies just get kind of lucrative deals to sell their data to typically big rich companies that then want to buy it. That's not a good world either, because it does shut out smaller players, and does have bad effects on the public for some of the most beneficial uses of scraping. That's why we think we kind of have to allow it in certain cases, or else we get a world where it's just a bunch of really big players, or this market where the information is just sold, but that doesn't in the end help anyone all that much.
No, not at all. And I think that this is, I know it sounds, and you and I talked about this, it sounds extreme to switch the defaults in the US, but I think that scraping is probably a unique enough activity, and one that for too long has been sort of lumped in with a lot of, I think, less harmful or less dangerous activities. And this would be a really good opportunity, I think, to break out scraping as its own unique thing, as well as think about, I know you mentioned that legal bases has not really found a footing in the US approach, but it has in the EU. And this could be a pretty good argument, at least for a careful expansion of US law into incorporating legal bases requirements, at least on this basis, right? And you could see how it would work in this set context rather than maybe as a general principle a little more effectively. And so we propose that as a workable and compromise to this otherwise really difficult tension that exists to this day in the law.
Yeah, I'll end with one thing because we'll wrap this up. But there was one law, a very early privacy law in the United States, that does kind of take an EU-style use-based approach, and it's the Fair Credit Reporting Act. Mm-hmm. It's been with us for more than 50 years. It was passed in 1970. And it basically involves actually a similar situation of a kind of early kind of scrapes, credit reporting agencies gathering all sorts of data from public records, from creditors. So some of it's publicly out there, but some of it's not. But they're gathering all this data and then using it for background checks and credit reporting. But this data is also gathered by others for other purposes. And I think the really interesting thing about the law, unlike most other privacy laws, is it says the law applies to certain uses. So if you use the data in these ways for background checks, for credit reporting, then you're covered. But if you don't use it in those ways, then you're not. So it's use-based. Very similar to the GDPR lawful bases. Here's the allowable use, but when you use these uses, you trigger obligations. And then those, interestingly, a lot of this data, not all of it, but a lot of it is in the public. And yet there are obligations that the law imposes. It doesn't have this kind of simplistic binary of public and private. It recognizes that there are uses of personal data, even if they're public, that can be potentially harmful to people and that need to be regulated. And so I think actually, if we go back to the beginning, this was one of the earliest privacy laws in the United States, the earliest privacy statutes. Go back into the beginning, maybe there was some wisdom 50-something years ago in the United States that we can revisit. But there is a small tradition that I think got abandoned. But if we look at that law, we can see there is precedent for an approach that is, similar to ours, or uses some similar concepts to ours.
Yeah.
thank you for joining me. I want to wrap this up. We could keep going on and on, but I think at this point, if folks are still interested in the paper, you can read the paper. It's available for free on SSRN, so you can download it and read. It's a long piece, but you can read and learn everything you want to know about this issue that we didn't cover here. And we really unpack all of our points and back it up with all the laws and concepts we're talking about.
Excellent. Thanks for having me on, Dan. I enjoyed the opportunity to talk about it.
Great. Thanks for joining me.